Students. Today is Monday, 11 April 2022. This will be the third and final lecture on the Supreme Court case of Atkins versus Virginia. The exam is on the 10th of May from 8 in the morning until 9:20. That's 29 days from now. I'm not trying to scare you, just make sure you keep up on the videos and the readings. The exam will cover 3 items. If you look at the reading list, you'll see that the exam covers the case that we're about to finish, which is Atkins versus Virginia. It'll cover the next item, which is an article by Gerald Dworkin entitled Paternalism, and it will cover an article by Douglas Huzak entitled 4 Points About Drug Decriminalization. So those 3 items will be tested on the third exam. A number of items are now posted for the Atkins case. Only one of them says optional reading, and of course that means you may read it. I recommend that you read it, but it won't be covered on the exam. All of the other items may turn up on the exam, so make sure you look them over carefully. And if you have questions about anything, you're certainly welcome to email me and ask them. I will post the article by Dworkin sometime today, later today, so you can get started reading it. It'll be taken up 2 days from now when I record the next lecture. Okay, let's get to the topic for today, which is the Supreme Court case. Now, we've spent 2 days discussing it already. The first of the 3 days was spent discussing the majority opinion. The second day was spent discussing the first dissenting opinion by Chief Justice William Rehnquist. And today we'll move on and talk about the second of 2 dissenting opinions. This one is by the late Supreme Court Justice Antonin Scalia. This is actually a little bit longer than either of the other 2 opinions. Okay, so let's get started. Let me move my notebook over. Justice Scalia begins by criticizing the majority. He says the court's decision, quote, finds no support in the text or history of the Eighth Amendment, unquote. That's on page 337. If you're following along on my lecture notes, I'm near the top of page 5. Scalia adds the following on the next page. Seldom has an opinion of this court rested so obviously upon nothing but the personal views of its members. Now that should sting. When the majority hears that or reads that, that should hurt them because they did not think that they were just imposing their personal views on the country. They thought that they were engaged in a serious, legitimate process of constitutional interpretation. So Justice Scalia is accusing them of something that they would deny doing. They would say, no, we're not just imposing our own personal views. We're trying to figure out what the evolving standards of decency are in this country. We're trying to figure out what the prevailing values are. And to do that, they looked at things like legislation to see what the various states are doing on this topic. Now, we don't want to go into a big discussion of constitutional interpretation. We've already, early in the course, when we discussed the case of the spelunkers, we looked at different views of statutory interpretation. How should a judge interpret a statute, such as the statute involved in that case? Now we're discussing an interpretation of the Constitution, specifically the Eighth Amendment, which prohibits cruel and unusual punishments. Now, many of the same standards may apply. Maybe all of the same standards apply. Maybe judges should read the Constitution the same way they read statutes. It's also possible that because the Constitution is the supreme law of the land, judges should use a different approach to interpreting the Constitution. I can tell you that the Constitution contains several open-ended terms that seem to invite judges to interpret them. For example, the Eighth Amendment itself prohibits cruel and unusual punishments. but it doesn't tell us anything about what constitutes a cruel punishment or an unusual punishment. The framers of the Constitution appear to have left it to judges of each generation to provide content to those vague terms. The Fourth Amendment prohibits unreasonable searches and seizures. The word unreasonable is vague and open-ended. And so the framers once again appear to have been inviting judges to give that term meaning based upon current values and current standards. So there's a big debate among law professors and judges and lawyers about how one should go about interpreting the Constitution. And Justice Scalia has a particular view of that. It's not the only view, but it's his view. His view is that in interpreting the Constitution, a judge should look at what the words meant at the time they were written, at the time the Constitution was ratified. Alternatively, a court or a judge should look at what the words were understood to mean at the time they were written or at the time the Constitution itself was ratified. Okay, so Justice Scalia has a particular view, and it's not shared by the members of the majority. And that's why he used this disparaging language, where he said, "Seldom has an opinion of this court rested so obviously upon nothing but the personal views of its members." Okay, let's take a look at the facts. The majority opinion was very short in laying out the facts of the case. In fact, if you go back to the majority opinion on page 307, you'll see that the majority said the following, and only the following, about the substantive facts of this case. Let me read it to you because it's quite short. Petitioner Darrell Renard Atkins was convicted of abduction, armed robbery, and capital murder, and sentenced to death. At approximately midnight on August 16, 1996, Atkins and William Jones, armed with a semi-automatic handgun, abducted Eric Nesbitt, robbed him of the money on his person, drove him to an automated teller machine in his pickup truck, where cameras recorded their withdrawal of additional cash, then took him to an isolated location where he was shot 8 times and killed. By the way, I posted an image from that ATM showing you what it looked like. Nesbitt was seated in his own truck between the two defendants, William Jones and Darrell Atkins. They made him tell them where his ATM was located and what his bank was, in effect. They drove there. They made him use his card to withdraw money for them. Now, they could have let him go, maybe stolen his truck, but they didn't. They drove him to an isolated location and killed him. So that's the entire recitation of facts in the majority opinion. Now let's turn to Justice Scalia's recitation of the facts. And you'll see that things are very different. I'm not saying that either one of them misstated the facts. My point is that Justice Scalia went into more detail. And in a moment, I'm going to ask you why that might be. So look at page 338. This is Justice Scalia's opinion. He has a longer paragraph, and notice the additional details that he provides. He says, "I begin with a brief restatement of facts that are abridged by the court, but important to understanding this case. After spending the day drinking alcohol and smoking marijuana, petitioner Darrell Renard Atkins and a partner in crime drove to a convenience store intending to rob a customer. Their victim was Eric Nesbitt, an airman from Langley Air Force Base, whom they abducted, drove to a nearby automated teller machine, and forced to withdraw $200. They then drove him to a deserted area, ignoring his pleas to leave him unharmed. According to the co-conspirator, that would have been William Jones, whose testimony the jury evidently credited or believed, Atkins ordered Nesbitt out of the vehicle and, after he had taken only a few steps, shot him 1, 2, 3, 4, 5, 6, 7, 8 times in the thorax, chest, abdomen, arms, and legs. Now, what are the differences between Justice Stevens's recitation of the facts and Justice Scalia? First of all, Justice Scalia pointed out that Atkins and his co-conspirator had been drinking alcohol and smoking marijuana. Okay, that may strike some people as irresponsible. He also points out that the victim, Eric Nesbitt, was an airman from Langley Air Force Base. Justice Stevens didn't mention that. Right now, why would Justice Scalia have put that in there? Well, this person, I think most people respect those who serve in our military, in our armed services. This was not some lowlife. This was a man who was a member of the military, and he just happened to be in the wrong place at the wrong time. Justice Scalia mentions the amount, $200 that was withdrawn. Justice Scalia mentioned the fact that Nesbitt, the victim, pleaded for his life. He pleaded with Atkins and Jones to let him live. He may have told them, look, I'll give you all the money you want. You can have my truck. Please, just don't kill me. Let me live. Also, notice the rhetorical effect that is conveyed by Scalia's writing. He didn't just say, as Stevens did, that Atkins shot Nesbitt 8 times. He counted them off. 1, 2, 3, 4, 5, 6, 7, 8. And the effect of that is to show you, is to put you there. You can almost hear the shots ring out. 8 of them, one after another. He didn't stop shooting, even though by then Nesbitt had surely fallen to the ground. It was overkill, surely. It didn't take 8 shots to kill Nesbitt. So Atkins wanted to ensure his death. And Justice Scalia points out where he was shot: the thorax, chest, abdomen, arms, and legs. So there's a lot more detail in Justice Scalia's recitation of the facts. And I suspect, I don't know this, but I suspect that Justice Scalia is trying to show the tragedy of this situation. And keep in mind that Justice Scalia thinks that the Virginia sentence of death should have been upheld and that Atkins should have been put to death. So Justice Scalia wants to, I think, convey the fittingness of putting Atkins to death. Look at this vile creature. Look what he did to this innocent man who was pleading for his life, who was shot 8 times. I think Justice Scalia is trying to suggest that death was fitting for Atkins. And it may be that Justice Stevens was glossing over the details because he ended up holding the view that Atkins should not be put to death, that he should be incarcerated, perhaps for his whole life, the rest of his life, but not put to death. So that's very interesting, isn't it? 2 justices who ended up on different sides of this case described the facts in ways that supported their own conclusion. And that's an art of lawyering. Every law student is taught how to do that. You should state the facts in a way that supports your own case, your own conclusion. Now, you must never misstate the facts. We were taught that. I vividly remember that being explained to us when I was a law student. Never, ever misstate the facts when you submit a brief in a case. But then Justice Stevens and Justice Scalia didn't misstate any facts, did they? Both of them said only what is true. The difference is how much detail they provided. And I've already suggested why that difference in detail was rendered. Now let's talk a little bit about Justice Scalia's principles of interpretation. As you can see in my lecture notes on page 5, according to Justice Scalia, there are two categories of cruel and unusual punishments. The first is this: those punishments that were considered cruel and unusual, quote, at the time that the Bill of Rights was adopted. So we have to do some history. We have to go back in time and study the past to determine what sorts of punishments were considered cruel and unusual at the time the Constitution was ratified. Anything that was considered cruel and unusual at that time would still be cruel and unusual today. Okay, that's the first category. Secondly, according to Justice Scalia, it would also be cruel and unusual for any punishments that are inconsistent with modern standards of decency, as evinced by objective indicia, the most important of which is legislation enacted by the country's legislatures. So Justice Scalia is agreeing with the majority and with Chief Justice Rehnquist that the court, to determine whether a particular punishment is cruel and unusual, the court should look at standards of decency, modern standards of decency, even if those standards of decency were not in place back when the Constitution was ratified. But, and here's the key part, Justice Scalia says that those modern standards of decency cannot be made up by the justices. They do not just reflect the justices' personal views or values or beliefs. These standards of decency have to be picked out according to legislation, because that's objective. Remember, personal views are in the head, they're subjective. What states have actually done through legislation is objective. It's out there in the world to be discovered. So Justice Scalia is going to look carefully at what the states have done, just as Justice Rehnquist sought to do, and just as the majority claimed to do. But you're going to see in a moment that Justice Scalia thinks that the majority played fast and loose with the facts of legislation. Okay, what sorts of punishments were considered cruel and unusual at the time of the founding, at the time the Constitution was ratified? According to Justice Scalia, only idiots fell within the category of cruel and unusual punishments, at least if we're talking about people with impaired mental abilities. Only idiots. And he points out that the term idiocy had a particular meaning back then, and Darrell Atkins does not fall within the scope of idiocy, according to what it once meant. His IQ, if you will, is higher than that of an idiot, or what was called an idiot back in the day. So really, all we should be looking at, according to Scalia, are those modern standards of decency. And to do that, we need to look at what the states have done through legislation. Okay? Why do we need to look at legislation? According to Justice Scalia, judges are more detached from society than legislatures are. Now, before I quote from Justice Scalia's opinion, let's think about that. If you had to say who is closer to the people and what the people's lives are like and what their beliefs and values are, would it be judges or legislators? And Justice Scalia is saying, he's coming right out and saying, legislators are closer to the people. Why? Well, because legislators are elected on a regular basis or thrown out of office. At the local, state, and federal level, lawmakers are elected by the people. Judges are not. Now, there may be states where some judges are elected, but at the federal level, judges are appointed by the president and confirmed by the U.S. Senate. They don't have to stand for office. The people do not directly vote for or against Supreme Court justices or any federal judges. So Justice Scalia thinks that the courts should defer to the legislatures. We live in a democracy where the people rule. Democracy means literally rule by the people. So a judge should respect the will of the people. And one way to do that is to look at what the people's elected representatives have done. So let's quote Justice Scalia at the top of page 6. I have several quotations extracted. Let's begin with something Justice Scalia says on page 342. Here we go. The court, and by that he means the majority, the court miraculously extracts a national consensus forbidding execution of the mentally retarded from the fact that 18 states, less than half, 47% of the 38 states that permit capital punishment for whom the issue exists, have very recently enacted legislation barring execution of the mentally retarded. Okay, that's the first point he makes. 18 states out of 38. That's less than half. That's only 47%. Only 47% of the states that allow capital punishment bar the execution of the mentally retarded. Is that a consensus? Justice Scalia is asking, and he doesn't believe that it is. Where's the consensus? Wouldn't a consensus require something like 75% or higher, maybe 90%? Perhaps not 100%. You don't need 100% for a consensus, but something in the range of 80 or 90 or 95. That would reflect a consensus. And we don't have anything close to that here, Justice Scalia says. 47%. Even worse, he says, quote, only 7 of the states, which is 18% of death penalty jurisdictions, have legislation that prohibits all executions of the retarded, all of them. He says no national consensus exists. Few, if any, of the states have had sufficient experience with these laws to know whether they are sensible in the long term. So even the states that have recently changed their laws to prohibit execution of the mentally retarded, not enough time has passed for them to know whether they want to keep those laws. Maybe 10 years down the road, when they've had some experience with the working of these laws, maybe they will repeal their laws or amend them. It's too early to tell what the consensus is. At least that seems to be what Justice Scalia is saying. Now, I made a diagram to help me understand what Justice Scalia is saying, and it may help you as well. I'm going to hold it up close to the screen, and if you want, you can pause my video when it's up against the screen, and you can then write down what I have on this handout. You can also make a screenshot, I suppose. But here's my handout. I'm going to hold it up to the screen for you. Let's see. Let me get it aligned. Okay. You see that? Can you see that? Okay, so that should allow you to pause the screen. Now, I'm going to indicate with my finger some things on this diagram. First of all, this rectangular box, think of as representing all 50 of the states. And Scalia is dividing it into 3 smaller boxes, here, here, and here. So let's go over what those small boxes contain. At the top, it says states that prohibit all capital punishment, 12. So at the time this case was handed down, now things are different now because this case was decided 20 years ago. So we're going to go by what the situation was at the time. 12 of the 50 states prohibited all capital punishment of anybody, mentally retarded or not. 12 out of 50, which is what, 24%. Okay, the middle box right here says states that allow capital punishment, but not for the mentally retarded. And there are 18 such states. 18 out of the 50 states are in this box. They allow capital punishment in at least some cases. They haven't ruled it out altogether like those 12 up here. But they don't allow it for the mentally retarded. So they have a two-pronged approach. Some people are eligible for capital punishment. The mentally retarded are not. There are 18 states in that situation. Still with me? The third box down here, here's what it says. States that allow capital punishment for at least some mentally retarded individuals. And there are 20 states in that box. So at the time this case was handed down, 20 of the 50 states allowed execution of at least some mentally retarded individuals. In other words, 20 states did not categorically prohibit execution of the mentally retarded. 30 states total, 12 plus 18, 30 of the states prohibit capital punishment of the mentally retarded. So the first point we could make, we could say this: how many of the 50 states, at the time this case was decided, how many of the 50 states prohibited execution of the mentally retarded? 30. 30 out of 50, which is 60%. Is that enough for a national consensus? Arguably, it's not. Right? 60% doesn't rise to the level of a consensus. It has to be more than that: 75, 80, 85, 90, maybe 95, though perhaps not 100. So the first point Scalia makes is that at the very most, 60% of the states prohibit capital punishment. But then he points something interesting out. He says, why should we take into account these 12 states up here at the top? These states prohibit all capital punishment, not just capital punishment for the mentally retarded. So if we're looking for whether there's a consensus on the specific question of whether a state allows execution of the mentally retarded, we should ignore those 12 states. We should focus only on those states that allow capital punishment for at least some individuals, not the states who have prohibited altogether. So we should focus on 38 states. How many of the 38 states that allow at least some capital punishment prohibit it for the mentally retarded? 18. 18 out of 38. Now over here on this side, you can see I have 18 divided by 38 equals 47%. So the 60% figure has shrunk. Only 47% of the states that allow some capital punishment prohibit it for the mentally retarded. Now clearly, if 60% is not a consensus, surely 47% is not a consensus. How in the world can something be a consensus when fewer than half fall into that category? 40% is fewer than half of the states. And guess what? It gets worse. Let me explain. You'll notice way over here on this side, I am breaking down those 18 states that prohibit capital punishment of the mentally retarded. Those are states that allow capital punishment, but they rule it out for the mentally retarded. Of those 18, 11 of them have enacted laws that apply only prospectively. Now, what does that mean? That means that they've changed their laws recently, and only cases that come about after they change their law will rule out capital punishment of the mentally retarded. Okay? It's prospective only. 7 of the 18 states who've changed their law say not only will new cases of the mentally retarded be prohibited, not only in new cases will the mentally retarded be not eligible for the death sentence, but even those who are on death row already will no longer be on death row. 7 states have made their new laws retroactive. So what these 7 states are saying is, we have recently changed our law to prohibit capital punishment of the mentally retarded. We've already got people on death row, mentally retarded people who are awaiting their execution, and we're not going to let them be executed either. In other words, the new laws are made retroactive. They apply to people who have already been convicted and sentenced to death, but who have not yet been put to death. So what is 7 divided by 38? Really, we should count only those 7 states, Justice Scalia says. Right? Why should we count a state that has recently ruled that the mentally retarded may not be put to death, but they're still willing to put to death those who are already on death row? I mean, that's a kind of a wishy-washy position. Right? They're still willing to allow some mentally retarded individuals to be put to death, those who are already on death row. So according to Justice Scalia, only 7 of the states take their new laws seriously enough to apply them retroactively. 7 states out of 38, which is only 18%. Now, follow my logic. If 60% is questionably a consensus, then surely 47% is not a consensus, and surely 18% is not a consensus. Only 7 states that otherwise allow capital punishment have said no execution of the mentally retarded, period, either in the future or for those who've already been sentenced to death. 7. So that's only 18%, which is fewer than 1 in 5 states. So do you see the point that Justice Scalia is making? He says that the majority has, well, let me quote him, miraculously extracted a national consensus. Miraculously. Really, there is no national consensus on this issue, Justice Scalia is saying. So notice, here we have Supreme Court justices arguing statistics. Right? And the reason they're doing that is because the issue is whether there's a national consensus. The majority says there is. Justice Scalia says, think again, there isn't. And ultimately, you'll have to decide which of these arguments is better. Justice Scalia, of course, thinks his argument is better, is more persuasive than that of the majority. Now, does it matter what the direction of change is? The majority seem to think so. The majority seem to think that if you look at the past few years, the change that has occurred on this issue has been all in one direction. States that previously allowed capital punishment for the mentally retarded now disallow it. And the majority was impressed by that fact and thought that that helps indicate a consensus. Here's Justice Scalia discussing that point. He says on pages 344 and 345, quote, given that 14 years ago, all the death penalty statutes included the mentally retarded, any change, notice he italicized that word for emphasis, any change except precipitate undoing of what had just been done was bound to be in the one direction the court finds significant enough to overcome the lack of real consensus. I mean, given that all the states uh, included the mentally retarded, any change has to be in a certain direction. So that can't signal, that can't be a measure of a national consensus. And then he points out, in any event, reliance upon trends, even those of much longer duration than a mere 14 years, is a perilous basis for constitutional adjudication. Adjudication just means judging. So he's pointing out that the court shouldn't be looking at trends in any case, including this one. Right? First of all, it's hard to discern what the trend is. Different people can look at the facts and discern either a trend or no trend, or if they agree that there's a trend, they might disagree about the direction of the trend or the magnitude of the trend. And trends can change. What may appear right now to be a trend could, in a year, not look like a trend as other states come in and do something else. And finally, Justice, on the point of statistics, Justice Scalia says, should we look at the number of states only? That's one way to do it, surely, but maybe we should look at the number of people in the states. Now, as you know, the state of Wyoming is a state unto itself. It's a sovereign state, just like Texas or New York or California. The population of Wyoming is much, much smaller than the population of, let's say, California or New York or Texas or Pennsylvania. So if we're just counting noses, so to speak, or states, Wyoming would be counted equally with a larger state. But maybe we should look at the population of the various states instead. If we're truly looking for the consensus of the people of this country, then we should look not at the number of states, but at the number of people in each state. So here's how Justice Scalia makes the point. This is on page 346. He says, the fact that 49% of the legislators in a state with a population of 60 million voted against the bill should be more impressive than the fact that 90% of the legislators in a state with a population of 2 million voted for it. So he's making this point that we should perhaps, if we're going to be counting numbers, we should look at the number of people in these states and rather than the number of states themselves. Okay, it's another good point that Justice Scalia is making. Maybe he's trying to show the absurdity of looking at this at all. Now, Justice Scalia, you probably don't know this, but he had a reputation for wit and sarcasm, which makes his opinions a joy to read. I think even people who find themselves disagreeing with Justice Scalia much of the time enjoy reading his opinions. They're filled with wit, sarcasm. He had a certain style. His personality always came through in his written opinions. In fact, it won't surprise you to know that his best friend on the court for many years was Ruth Bader Ginsburg. He and she disagreed emphatically on most issues, or at least many issues, and yet they were best friends. They and their spouses went out on the town together to operas, which they loved, restaurants, and other activities. That's a nice thing, isn't it? Justices who disagree fundamentally about the law could put it aside and enjoy each other's company. But here is an example of Justice Scalia's sarcasm. This is from page 347. The prize for the court's most feeble effort to fabricate national consensus must go to its appeal, deservedly relegated to a footnote, to the views of assorted professional and religious organizations. That's first. Secondly, members of the so-called world community. And third, respondents to opinion polls. Notice, Justice Scalia has the same problem with the majority opinion that Chief Justice Rehnquist had. We've already gone over that, so I won't repeat myself. Justice Scalia takes a jab at the world community. He says, the world community, quote, whose notions of justice are, thankfully, not always those of our people. Ooh, ouch. What is he saying there? He seems to be saying that we should not look to foreign countries when we interpret our Constitution. No, people in Europe may think that Americans are barbaric. Many of them do. They say that we have too many guns. What's wrong with those Americans? Why do they allow private ownership of guns? That's why they have so many gun-related killings, school shootings, and so on. Europeans look down on us because we have guns. We believe that we have a right to own guns, as reflected in the Second Amendment. They also look down on us because we allow capital punishment. Not all states do, but many of them still do. So Europeans, in particular, look down their noses at the United States, thinking that we're backward or barbaric even. Justice Scalia will not have that. He will not stand for that. He would defend our Second Amendment. He would say that we in the United States believe in individual liberty, and we should be free, and we are free to own and use firearms for self-defense, for collecting, for target practice. And should our government ever oppress us, individual citizens will have weapons to defend themselves from their own government. So Justice Scalia would not take this lying down. In fact, he goes on the offensive. He says, the world community has notions of justice that are thankfully not always those of our people. He seems to be saying that we have a more refined sense of justice than other countries. And we should not apologize for the way we do things here. Now, I've compiled a short list of some of the atrocities committed in Europe. And you could expand upon this and talk about atrocities all over the world. The Crusades were conducted in Europe long ago with a great toll and death. The Inquisition. If you don't know what these terms refer to, look them up. Go to Wikipedia, type in Inquisition, and read what it says there. The French Reign of Terror after the French Revolution of 1789. Read about it. In France, the guillotine was invented. Heads rolled, literally, during and after the French Revolution. People's heads were cut off, men and women, old and young. Some of the very people who used the guillotine against their political enemies ended up being guillotined when their time came. I think the inventor of the guillotine was guillotined. How's that for irony? In Spain, another European country, the garrote was invented, a particularly macabre way of putting people to death. In England, the broadaxe was used for executions. Europe also gave us Nazism and Joseph Stalin, other instances of genocide. So we should not apologize. We in America should not apologize for retaining the death penalty or insisting upon the individual right to own firearms. Justice Scalia would not put up with that for one moment. And I think that's what he's getting at here. Europe has its own notions of justice. We have ours. Look what their notions of justice gave them. And I just compiled a partial list. Do we want that? Arguably not. Okay, a few more items and we'll be done for the day. Justice Scalia discusses the majority's judgment. On page 348, he writes, "The arrogance of this assumption of power takes one's breath away." And it explains, of course, why the court can be so cavalier about the evidence of consensus. It is just a game, after all. Ouch. That has to sting. That has to hurt. I wouldn't want to be on the receiving end of Justice Scalia's words because they're quite biting. He's saying flat out that the majority is playing a game, that they are cavalier about the evidence of consensus. Scalia thinks that his analysis of the evidence is superior to that of the majority, and that there's the correct analysis, which is displayed here, shows clearly that there's no consensus on this issue. The majority just manufactured it miraculously out of thin air. And he concludes that for the majority, this is just a big game. He doesn't say this, but if you read between the lines, he is accusing the majority of engaging in what we've called in this course already result-oriented jurisprudence. He's implying, he's not stating it out explicitly, but he's implying that the majority made up its mind to prohibit the execution of the mentally retarded and then worked up a justification for that conclusion. The conclusion was made on other grounds, such as their personal moral views, and then they stitched together a legal justification for that conclusion. It's not really a conclusion. It's a judgment made on other grounds, illegitimate grounds, such as personal morality, and then made to look respectable or legitimate by putting together a legal argument. But Justice Scalia said the legal argument holds no water. It's a sham. It's just a big game to Justice Scalia. The majority is playing the game, and they've just decided they don't want to see the mentally retarded put to death. All right. Remember when the majority opinion said that the two purposes of punishment, specifically capital punishment, would not be served by putting the mentally retarded to death? Those two justifications for punishment are retribution and deterrence, general deterrence. And the court said that retribution isn't served because the mentally retarded are not culpable enough to deserve death. They are culpable enough to be convicted and sentenced to life imprisonment, but not culpable enough to be put to death. Remember when I pointed that out, the strangeness of that I call that threading the needle? How can you be blameworthy or culpable enough to be convicted of a serious crime and have to spend the rest of your life in prison, but not culpable enough to be put to death? The majority never explained that. And I think Justice Scalia is pointing out the absurdity of that. Secondly, what about the deterrence argument? Justice Scalia says that deterrence doesn't have to work for everyone. I mean, nobody would think that deterrence, that in order for the deterrent rationale to apply, everyone must be deterred. Some people are undeterrable. That means they're incapable of being deterred by any punishment. Deterrence as a rationale for punishment requires that many people, perhaps most people, be deterred. Not that everyone, literally everyone, be deterred. And Justice Scalia says, surely at least some mentally retarded individuals are deterred by the threat of death. And that's enough to make the deterrence rationale applicable to this case. So we should put the mentally retarded to death, or at least we may put them to death on the ground that doing so will deter at least some mentally retarded individuals. Doesn't have to be all of them. What about the culpability of the mentally retarded? Let's take a look at what Justice Scalia says about that. Let's look at page 350. Let me get my notebook down for a moment. Go to page 350 of the opinion. Let's see what Justice Scalia says about the culpability of the mentally retarded. Okay, I'm almost there. Here's what he says. This is near the bottom of page 350. Surely culpability and deservedness of the most severe retribution, such as death, depends not merely, if at all, upon the mental capacity of the criminal above the level where he is able to distinguish right from wrong, but also upon the depravity of the crime, which is precisely why this sort of question has traditionally been thought answerable not by a categorical rule of the sort the court today imposes upon all trials, but rather by the sentencer's weighing of the circumstances, both degree of retardation and depravity of crime in the particular case. The fact that juries continue to sentence mentally retarded offenders to death for extreme crimes shows that society's moral outrage sometimes demands execution of retarded offenders. Sometimes it demands it. Now, what is Justice Scalia saying there? Before I answer, let me go back to back to my notes so I can pick up where I left off. Justice Scalia is saying, let's not get hung up on IQ tests as a measurement of mental retardation and specifically of the culpability of those who are mentally retarded. We need to take into account IQ, or cognitive ability, yes, he doesn't deny that, but also something else, the depravity of the individual as reflected in the severity of the crime, the seriousness of the crime. Now, how serious was the crime committed by Darrell Atkins? Well, he's already recited the facts. Atkins refused to show mercy on Nesbitt, the victim. He shot him 8 times. That surely is evidence of depravity. Even if Darrell Atkins had a lower than average IQ, even if, strictly speaking, he falls within the class of the mentally retarded, we should also look at how depraved his actions showed him to be. And I think just the unspoken assumption is he was quite depraved. Just look at what he did. It wasn't enough to take the money or the property of the victim. They drove him to an isolated spot, and in spite of his pleas to be left alive, shot him 8 times, multiple times. A couple more points and we'll be done. The majority pointed out that the mentally retarded may not be able, because of their retardation, to assist their attorneys at trial. And Justice Scalia says that may well be true, but that raises a different issue. That raises not an Eighth Amendment issue, but a due process issue. It raises a Fifth Amendment and 14th Amendment due process issue. And that was not argued in this case. So the court should not even discuss that, right? Whether Atkins was able to assist his attorneys at trial is not an issue that's before the court. And so he's criticizing the majority for even bringing that up. Atkins could well have raised that at his trial. And if he had raised it, he could argue it on appeal. But presumably he didn't raise it, and the court should not now be examining that or even taking that into account. Okay, final page of my lecture notes, page 7. Justice Scalia is not against states legislating against capital punishment. Remember the 12 states? Remember the 12 states who have abolished all capital punishment across the board? States, I think, well, I won't speculate, but I was thinking maybe Massachusetts is one of the 12, but then maybe it's not. So I'm not going to mention any particular state. In other words, I won't try to guess which states are among those 12. But let's say one of those states that is among the 12, it has chosen to prohibit capital punishment for anyone, including the mentally retarded. Does Justice Scalia have a problem with that? He does not. Justice Scalia says it's entirely up to each state to determine whether it will have capital punishment on its books. So he would, if all 50 states enacted legislation that prohibited capital punishment, Justice Scalia would have no problem with that. Okay, do you see my point? But that should be done by the legislatures of the states. It should not be done by the Supreme Court or any other court. It should be done by the elected representatives of the people, and that would promote democracy. So here's what Justice Scalia says about that on page 353. There is something to be said for popular abolition of the death penalty by state legislatures or for federal capital crimes by Congress. There is nothing to be said for its incremental abolition by this court. So Justice Scalia's opinion seems to be this: capital punishment is entirely up to the states, in general and for particular classes of people like the mentally retarded. If a state wants to ban capital punishment altogether, it should be able to do so. That's Justice Scalia's view. If a state wants to allow capital punishment for anyone, including the mentally retarded, it should be able to do so. If a state wants to allow capital punishment except for those who are mentally retarded, it should be able to do that as well. In other words, see these 3 boxes here? According to Justice Scalia, it's entirely appropriate for a state to be in any of those 3 boxes it wants to be in. If all 50 of them ended up in the same box, that's fine. They've chosen it. And our Constitution allows states to do things like that. Unless there's an explicit provision of the Constitution that disallows states from doing something, they may do it. So there's a presumption that states may enact whatever legislation they choose unless something in the United States Constitution says, no, you can't do that. And on the question of capital punishment, there's nothing in the Constitution that prohibits that, except the cruel and unusual punishments clause of the 8th Amendment. And remember, Justice Scalia says that needs to be interpreted in accordance with what was understood at the time the 8th Amendment was ratified. Anything that was cruel and unusual at that time would still be cruel and unusual today. For example, what if a state at the time of the founding prohibited as cruel and unusual punishment, well, let me back up. What if it was understood at the time the 8th Amendment was ratified that drawing and quartering someone was cruel and unusual as a punishment? You know what that means? That means the person's hands and feet are tied to a rope. The person is pulled in 4 directions, and eventually the body is cut or broken into 4 parts. That's called quartering, drawing and quartering. You can imagine how gruesome a death that is, how painful and humiliating, but mostly painful. If it was understood at the time the 8th Amendment was ratified that that sort of punishment is cruel and unusual, then it would still today be cruel and unusual. That seems to be Justice Scalia's view. But if something was not considered cruel and unusual at the time of the ratification of the Eighth Amendment, then states today may, if they choose, use that method to execute those who have been duly convicted and sentenced to death. So Justice Scalia is considered what's called an originalist. He wants to look at the original understanding of the words used in the Constitution. And that for that we need to do history. We need to go back and look at the evidence for how the Eighth Amendment was actually understood by those who drafted and ratified it. Okay, now the final point I'd like to make has to do with the practicalities of this ruling. Justice Scalia is worried that if Justice Scalia is worried that if a state enacts a law that excludes the mentally retarded from being put to death, that will open the door to people feigning or faking mental retardation. He says on page 353, the symptoms of mental retardation can readily be feigned or faked. So he's worried that this decision of the court, the majority ruling, is going to open the door to all kinds of fakery in every state that excludes capital punishment of the retarded but otherwise allows it. And that's not good for the law to invite fakery at a trial. Right? That's one of the bad consequences of the majority's ruling. So let's take a look at these three categories. Is there any problem with fakery for the 12 states who exclude capital punishment across the board? No, there is not. Those states say nobody may be put to death, even the mentally retarded, or especially the mentally retarded. Nobody may be put to death. So nobody has to claim to be mentally retarded to escape capital punishment. Everyone escapes it. The second category are those states that these are states that allow capital punishment, but they exclude it for the mentally retarded. In those 18 states, fakery will occur. Okay? In this category down here, these are states that allow capital punishment in at least some cases, even for the mentally retarded. So there's no problem of fakery there either. So the fakery problem will occur for these 18 states, the ones who in effect grant an exception to capital punishment for the retarded. All right, that's enough. We're an hour and 3 minutes in. I've given, I think, a pretty thorough lecture on this case. It took 3 class periods. We've now gone over the majority opinion and 2 different dissenting opinions. There's a little bit of overlap between the 2 dissenting opinions, Rehnquist and Scalia, but they do raise different issues to some extent. I hope you, despite the depressing nature of this topic, I hope you enjoyed reading this case. If you end up going to law school, I hope that the cases we've discussed in this class are of some help to you. But even if you never go to law school or never have a job that's law related, I think every citizen should have some understanding of what's involved in a legal case and specifically how the Supreme Court operates. So I hope you have gotten a little bit of an understanding of the history of the court and its practices, a little bit about the politics of law, if you will, a little bit about the law itself, and a little bit about the way that the court operates in terms of majority and dissenting opinions. Okay, this is a philosophy of law course. It's not a law course, so when we read these cases, we are primarily looking at the arguments and the reasoning of the justices. We're trying to isolate the disagreements between various justices, and I want you to understand basic legal concepts and distinctions. So on my exam, I will focus on the philosophical um, parts of these opinions. Now, I'm not saying that there will be no other questions asked. I'm going to try to keep you honest. I want to make sure you read these opinions carefully and slowly. So I may put in a question about, I don't know, what was the outcome of this case? Was it a 5-4 case? Was it 6-3, 7-2, 8-1, 9-0? There may be a question just to see how carefully you read the case. Okay, that's enough for today. Remember, I'm going to post the next reading later today. It's by Gerald Dworkin, and you should get started reading it. Before you watch my next video on Dworkin, you should read, let's say, half of his article. And then when you watch my video, much of what I say, maybe all of what I say, will make some sense to you because you've already grappled with the article. Okay, that's enough for today. Have a great day, and I'll see you either in class, if you choose to come, or on the video screen next time.